call James Kelly. Mr Kelly, you have 8 minutes.
Thank you very much, Deputy Presiding Officer. I welcome the opportunity to close this debate on behalf of the Labour Party. And as a member of the Justice Committee, I'd like to take the opportunity to thank the clerks and the team at Spice for the amount of work they put in assisting the committee over, as Bill Aitken said, the 9 sessions in which we considered this bill at stage 1. This was, in a sense, my first outing on the Justice Committee when we came to consider this piece of legislation, and I was advised that it would be a relatively calm and uncontroversial journey through the process. How wrong that proved to be, I'm afraid. As we took the different evidence sessions, it became clear that there were strong views on either side as to the benefits and disadvantages of this bill, and clearly, as many have said in this debate, there are divisions within the legal profession and the Law Society, and that's made it very difficult for the members of the committee to navigate their way through this bill, to try and understand it, to try and grapple with the issues, and to try and basically map a way forward which will ensure that the passage of this bill benefits not only the legal profession but also the consumers and the users of legal services throughout Scotland. As I said, there are strong arguments for and against that. In favour, there are those who point to the modernisation of legal services in England and Wales, and a feeling that we don't want Scotland to be left behind. And if we are left behind, Scottish firms potentially could become disadvantaged. As the Minister has pointed out, there are potential economic advantages to moving down the ABS route, and we don't want to disadvantage our Scottish legal firms, and we also want to give an opportunity to, if we can, to boost the Scottish economy in that sector. And as Consumer Focus Scotland have pointed out, the benefits of the bill do give the opportunity to help consumers by giving, if ABS is proven to be successful, by giving better access and reduced prices. Against that, the strong arguments that we've heard are that the independence of the legal profession is under threat, and that long-standing arrangements such as a guarantee fund would be in danger of being terminated. There are also fears that it would spell the death knell for many small firms, and also, as has been said by many, there's a danger of unscrupulous third parties becoming involved. I think the role of the committee in assessing the effectiveness of the legislation wasn't helped by the lack of evidence. There were obviously some strong evidence at the committee from the Law Society, but as Robert Brown has pointed out, some of the other evidence wasn't so strong. And I also think it was difficult because there weren't strong international examples. The changes that have been introduced in England and Wales have yet to be implemented, so we can't see the advantages or the disadvantages of that. The Minister has quoted Australia, but there are no sort of strong examples near to home to allow us to assess whether this is the correct route to go down. Through all this, we really have had the divisions that have taken place within the Law Society, and the number of processes that they've gone through in terms of taking a different view on ABS. As far back as 2008, there was actually quite a strong vote in favour. We then had the special general meeting, which was actually halted. In between times, a referendum voted narrowly in favour of alternative business structures, and then the reconvened special general meeting voted against. We now await the discussions of the executive of the Law Society and a further AGM, and certainly I'm sure we all wish Ian Smart and the officers well in terms of coming up with a consensus and a way forward that can be agreed by the vast majority. of the members. Clearly that is not going to be an easy task. I think there are a number of important issues that have got to be addressed as we move to stage 2. There clearly are concerns that this legislation could undermine the independence of the legal profession. I think, as Bill Butler and others have said, the proposal put forward by Mike Daly of Govan Law Centre in terms of co-ownership of a 25-75 split is one way forward, and Mr Daly has been quite critical of the ABS structures, and I think that gives an opportunity, to try and build some consensus. I think the issue of regulation is a complex one, and there were some concerns at the committee about the power vested in ministers. And I do welcome the Minister's comment to look at an enhanced role for the Lord President. I think that is the correct route to go down. I think David McCletchie is right to point out that we do want a level playing field no matter how many regulators we have, and it's important that we see those proposals coming forward. I think if this change is to be successful, it's got to be properly resourced. As I said earlier, ICAS have said that the new system in terms of regulation would be costly to operate, and I think the financial memorandum is sketchy in detail, and there aren't a great deal of the finances to back this up aren't adequate. In terms of moving applications through the process, it's a minimum of £27,000, a maximum of £71,000, and the monitoring of the process is a maximum of £48,000 in terms of staff numbers. I think if we're to address the concerns that members have raised about potential unscrupulous third-party involvement, then we need greater resources in order to carry out that task properly, and not the paltry sums that we see currently in the financial memorandum. I think, as Bill Butler and Richard Bacon and others said, it's important that we're able to demonstrate that these proposals give adequate access to justice. I think there is an important role for the Minister here in, as Robert Brown pointed out, I think very helpfully, getting the interested parties round the table, discussing the issues and to try to hammer out a way forward. I recognise that the Minister wants to make a robust defence of his bill, but I think some of his criticisms just went a bit too far, because I think he does have to reach out to those in the legal profession that have been critical and to get them on board so that we can all move forward on this issue. Labour supports the introduction of this bill at stage 1. I think it's got to be heavily amended at stage 2, and we'll wait further developments with interest.